Okay, let's talk equitable remedies in contract law. Rule script. Equitable remedies are awarded when no adequate remedy at law exists. Equitable remedies are awarded when no remedy at law exists. One, it could be just too speculative or too complicated. And third, money is inadequate to compensate. And this would normally arise in the sale of what? Land or something very specific like art or you name it. But it definitely arises when money is inadequate to compensate a party, loss of a business, loss of a piece of property. Okay, rule script. Equitable remedies are awarded when what? That's right, no adequate remedy at law exists. And one other thing. The common law equitable remedies try to return the party to the status quo ante. Okay, so our rule script is this. Equitable remedies are awarded when no adequate remedy at law exists and are intended to return the parties to the status quo ante. Okay, let's first talk about mutual and unilateral mistake. Remember, a mutual mistake is when both parties are mistaken about a material fact or basic assumption of the contract, and the contract can be avoided or is voidable on that basis. Whereas a unilateral mistake occurs when one party is mistaken and the other party knew of the mistake, caused the mistake, took advantage of the mistake, should have known of the mistake, right? So under a unilateral mistake, the contract will be upheld unless the other side knew of the mistake, should have known of the mistake, took advantage of the mistake, caused the mistake. This is grounds for avoidance of a contract. It is also grounds for rescission of a contract. Rescission of the contract is the judicial remedy. So mutual and unilateral mistake, we're covering that first because contracts are voidable, and it is also grounds for rescission of the contract at law. Okay, next. Okay, so let's talk rescission in general. Rescission returns the parties to what? Status quo ante. In addition to mutual mistake and unilateral mistake, you can get rescission if neither party materially performed. What if somebody partially performed, but they didn't finish the whole job? You can get a release, but there has to be consideration. So for rescission as an equitable remedy, rescission returns the parties to the status quo ante. If nobody performed on the contract, rescission. If somebody partially performed, then there will need to be consideration for the release. Consideration and a release. Okay, so rescission, nobody performed, great, rescission. Somebody performed, consideration and a release. All right. There, of course, is an injunction. You can get a court injunction. Stop breaching the contract. Stop violating your non-compete. You can get a declaratory judgment. What is a declaratory judgment? Remember, it is just a court's opinion on the party's rights under the law or a contract. But what's our dispositive overriding role? It's a court opinion with the force and effect of a final judgment, a declaratory judgment, a court opinion regarding the party's rights that has the force and effect of a final judgment. What does it have? The force and effect of a final judgment. So we can get rescission, mutual mistake, unilateral mistake, nobody performed, partial performance, released with consideration, declaratory judgment, court opinion, force and effect of a final judgment. We can get an injunction, We can get reformation. Okay, so reformation of a contract would give correct expression to the party's intent. Reformation of the contract is an equitable remedy to give the correct expression to the party's intent. Okay, when do we get reformation? Usually due to a mutual mistake. Remember, both parties are mistaken about a material, fact, or basic assumption of the contract. Neither of them was at fault. Neither of them bore the risk of the mistake. So we're going to return them to the status quo ante. We can get rescission, we can avoid the contract, or we can get reformation. Okay, this is an exception to the parole evidence rule, so outside evidence can be used to prove it. Finally, last, we can get specific performance. Specific performance can be sought when it's obviously something unique or special like land, but it will never be granted for personal services. Why? Because it violates the 13th Amendment's prohibition on involuntary servitude. You're never going to get specific performance for a personal services contract ever. When could you get specific performance other than a sale of land or something unique? When the parties just won't cooperate. Okay, let's run through this one more time fast. An equitable remedy in contract law is awarded when no remedy at law exists and money is inadequate to compensate. Equitable remedies are intended to return the parties to the status quo ante. All right, our first grounds are mutual or unilateral mistake, mutual mistake of material fact or basic assumptions. Neither of them bore the risk, that's critical. And we can get rescission of the contract, we can avoid the contract, and we can also get, that's right, reformation of the contract. Unilateral mistake. One party is mistaken about a material fact or basic assumption, and the other side, remember, it's valid unless the other side should have known of the mistake, caused the mistake, took advantage of the mistake. We can get rescission, we can avoid the contract. What can't we get? Reformation, because there's fault. Okay, so an injunction, easy. Prohibition on continuing to breach the contract. Declaratory judgment. What's our dispositive rule? A court opinion with the force and effect of a final judgment. Okay. Rescission or cancellation, when neither party materially performed. You can rescind it. Do you need consideration? No, nobody performed. What if somebody performed? You're going to need a release with consideration. Okay, and we never get specific performance for personal services, but we might get specific performance as it's unique or special, or the parties just won't cooperate and the court is sick of it. And those are our equitable remedies.